Karen Reed is in a fight with the Norfolk County District Attorney's office over Michael Proctor's telephone downloads. And in the Turtle Boy case, after a Zoom hearing, the court kicks the can down the road for almost a year.
You lost. And you know what you did.
I'm Attorney Andrew Myers. This is About the Law. Joining me is California Attorney Yoli Medina. How are you, Yoli?
I'm fine. How are you?
I'm pretty good. Where do you want to start? Aidan Keaney has often said that, all they do in court is kick his case down the road, whether that's good or bad or delaying the inevitable. It's hard to say. There was a hearing on Zoom on December 5th, a Friday, and it felt like Friday the 13th because the parties were all there. But it didn't seem like a whole lot got done other than, kicking things down the road more. Am I right about that?
Yeah, you're right about that. And I kind of feel the same way with my cases. It just gets kicked down the road. It's continued. But I don't know how it is with the courts over in your state. We're backed up with, a lot of cases. I don't know if that's the same with Massachusetts or they're just a little disorganized or...
Well, my perception, correct me if I'm wrong, is that this doesn't have anything to do with the courts being clogged up. This has to do with yet another judge coming in, Judge Christopher Belezos, and he held a Zoom hearing, and the parties were there, Timothy Bradel, Mark Betterow, and Robert Cosgrove, the special prosecutor. And it opened up by the judge saying, well, Judge Krupp's decision not to make any immediate decision on the mega motion is, what it is. There's a decision not to decide on that. Then there was a comment about, well, he might rule on it by the end of the month. And I think that referred only to the motion to
disqualify.
Right, the motion to disqualify the special prosecutor, Robert Cosgrove.
I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now.
So then they got into it, and they said, well, if Judge Krupp denies access to the Karen Reed cell phones, that's the end of the matter. However, Special Prosecutor Cosgrove, who is still in the case, whether people like it or not, said, well, if they do allow that material, then there has to be probably an evidentiary hearing.
If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion or allowed it in some modified form to set up the taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team. And then at that point, the Commonwealth would get the information as approved by the court to go through it. And assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this: as I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download.
So if that motion is allowed, then the taint team has to get started going through all of the data in the 2 cell phones that they seized from Karen Reed, and still to this day, the end of 2025, have not been returned to her. And that would be quite a lengthy process, I would think. And at the end, the opposing attorneys would have to go through it. Now, Mark Betterow, who has appeared on this channel and many others I know, said that he feels that the motion for disqualification has to be addressed first before they get into the other matters. He says that has to be addressed in the first instance, because if the special prosecutor, Mr. Cosgrove, is taken out of the case, it's kind of like starting from the beginning again. The judge really was not excited about that. Judge Christopher Belezos, I hope I'm pronouncing that right. As a Massachusetts attorney, I should be able to pronounce all the judges, but there are many of them. The judge seems pretty cool to the motion to disqualify. I'm not saying that he is not going to allow it, but his comments, tell me if I'm right or wrong, seem to indicate that he's really not excited about that motion.
Right. He said, well, we'll assume that motion to disqualify is going to be denied. Then what? And then he went on. So it didn't sound, and he wasn't particularly interested in hearing anybody talk about the motion to disqualify and why it needed to be heard first. He kept saying, we'll get to that. And then eventually he set the motion to disqualify for January 23rd.
Yes,
And
23rd.
Yeah, and he also said, by the 13th, January 13th, there will be no more filings on this motion to disqualify. So at least he set a date, so it's not filing things at the last minute right before the hearing. It's crazy.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did, up until the point where
I'll get to that. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come. And what Attorney Cosgrove chooses to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later. And it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
Right. So the judge had also said in one of his comments was that he thought that the motion seemed overbroad. So even though there is going to be a motion hearing it's scheduled as of now anyhow. You never know. January 23rd, and as you pointed out, the filing deadline would be January 13th. So now they get back to the issue of the motion to dismiss, the mega motion, so it's called. And Mark Betterow pointed out that, we're still getting discovery in dribs and drabs, and he's been saying that all along.
Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drabs without, as far as we can tell, respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks, we're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control. And we haven't received that.
I don't know who you're talking
Jennifer McCabe.
about. Okay. Mr. Cosgrove?
I will look into that as to Mr. Betterow's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed.
Interesting exchange came when Mark Betterow pointed out to the judge that one of the most important witnesses testified as to the grand jury as to threatening images and communications. And Mark Betterow says, we haven't received that yet. The judge said, oh, an important witness who? Betterow, without hesitation, said, well, Jennifer McCabe. So a lot of issues. Cosgrove, the special prosecutor, Robert Cosgrove, a retired Superior Court justice in Massachusetts, said, he used these words. He said, the check is in the mail. He had just, where have you heard this story before? He had just put some discovery materials in the mail the day before the hearing. Now, haven't we heard that one before?
Yeah. We've heard it in Koberger. We've heard it in Karen Reed.
I'm just talking about Robert Cosgrove. It seems like every time there is a motion hearing or a status conference in the Aidan Keaney Turtle Boy case, that's what we're talking about. Oh, I just put some discovery in the mail yesterday. One day, he actually walked into the court with documents and gave them to the other side in court. Now, how do you have the opportunity to read? I've been sandbagged like that. That's the word for it. When people walk into court and give you, oh, I just filed this with the clerk. Here's your copy. What? Wait a minute. No.
Yeah, I know. The judges need to be stricter about those things. And for some reason, they have a lot of discretion when it comes to that. But they'll continue it so that the other side can have an opportunity to read it. But that is what causes the continuances, is these late filings. And of course, today was supposed to be the day that the mega motion was going to be decided. But because Cosgrove filed his filings late, it turned into a status conference. And I don't even think they got a date for the mega motion, did they?
No, they just kind of generally, and here's what I mean by kicking the can down the road. They just kind of generally said by mid-November, file everything. By mid-November, we'll probably have a status conference. The first thing the court said was, well, maybe in October. And some of the attorneys have pre-existing scheduling issues. Attorney Bradel said that he has a murder trial in October, so it gets pushed to November. One of the other overriding, continuing things that's just another kicking of the can down the road was Mark Betterow pointed out that Robert Cosgrove has often used as a delaying tactic, saying, well, the initial special counsel, Mr. Mello, is very ill. He's gravely ill, and he really can't do anything, and he's got a lot of documents. And Betterow said, well, you know, why doesn't the Commonwealth just send someone over to his place and get all the documents and retrieve them all? I said that in a previous episode. I said, didn't they ever hear of FedEx or couriers?
Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits from 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I feel like we're back in the 1980s where there's actually literal paper files that he has, and they're not in the office, they're at his home, and somebody has to go pick it up. It just sounds very strange. In this day and age, things should be scanned, whatever it is, into a computer so people can have access to it so that it's easily able to be transferred to another person. But I mean, you know, it's like, I understand, you know, attorneys get ill, and that I'm sympathetic to that.
I
But
am
still,
too.
yeah, but still, you know, like the judge said, Mr. Cosgrove, you have to comply with the rules of discovery. And I'm not going to micromanage. I'm not going to tell you what to do and tell you you must go to his house or you must do this. But whatever it is you have to do it so that you comply. And it's common sense. But I just feel like it's just red tape. I don't know if it's intentional or if it's just people aren't thinking. I don't know.
That's one of the things I liked about this judge. He says, I don't care how you do it. I'm not going to micromanage you, but do it. You know, and it would seem to me that they should say, just get it done.
Well, I'm going to leave the details of how Attorney Cosgrove complies with Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible.
So that was a good thing that this judge said. And then from my notes of watching the conference, the judge said that you should assume that and this is one of the other reasons I say that I don't think that this judge is going to disqualify Robert Cosgrove. And I don't think the Aidan Keaney fans can be too happy with that at this time. The judge said, assume that there is no disqualification. Then should we go forward and try the two outstanding indictments together?
Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradel, Ms. Bedroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are
Sure.
all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves I want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
It's a very fair characterization, Your Honor. You know, there's a bit more to do on the newer indictment. We don't have grand jury minutes even yet, and
no, I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Carney.
It's Carney, Your Honor.
Carney, I apologize.
Okay.
So look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done.
And it goes down from there. He asked Robert Cosgrove, how long will it take you to present the case to the jury? And there was no clear answer. He said, well, I have 6 to 7 victims. I have a number of victims to put on the stand, a number of videos to put on the stand. And realizing that he was kind of meandering around, Robert Cosgrove said, well, maybe about 2 weeks.
How long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we've got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
That did not include attorneys Bradel and Betterow, with their witnesses. How long will they take to cross-examine? Because as we've learned in the Karen Reed case, the Brian Walsh case, and others, the cross-examination can take an equal amount of time as the direct or longer. So there was really a non-answer, but swirling up in the air is that the trial of Aidan Keaney would be maybe about 2 weeks. So when the judge asked, well, when would you people be ready? Tim Bradel said, mid to late fall next year, 2026. Cosgrove's only answer was that it's a complicated case. That's when, as we discussed before, the judge said, well, how about late October? And that is when Attorney Bradel said, well, I've got a murder trial in October. So it seems all destined to come up in November of 2026.
Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th? Any of those?
I can pretty much make those dates work. And I've checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have access to that docket right now. But pencil yourself in for around that time. And we'll pick this up once we get through the motion to disqualify, which will be on the 23rd. Okay? So, but let's try to work our way towards that date, and get this thing in front of a jury.
When asked whether there was anything else, Robert Cosgrove said, well, there's an issue out there because Judge Doolin, how many judges have been in this case? Comment down below, please. How many judges have touched this case? Robert Cosgrove said he was confused that Judge Doolin had previously issued an order that all filings have to be submitted on paper. Yoli, as you know, most of the courts do things electronically. I practice in Massachusetts, mostly in Essex County and Middlesex County, which, if you're familiar with Massachusetts, Essex is northeast of Boston. It's the North Shore and all the way up to the New Hampshire border. And Middlesex County is just to the west of that, encompassing Lowell, Massachusetts, all the way down through Woburn, where one of the superior courts is now, down to Cambridge. So huge county. Those are the two counties I'm most familiar with. We file everything electronically. Gone are the days of jumping in your car and driving down there and getting a date stamp. But anyhow, so
fax filing, I don't know if you've had fax filing, but I mean, before e-filing, there was fax filing. So, I mean, I would think that the courts would have something similar and not just paper file. And then, but going back to your point about what Cosgrove was complaining about, he said the judge in response said, well, as long as you file a paper copy, that's fine, but you need to get an electronic copy to the court. Okay, so how do you do that? Where do you email it to? I mean, what?
Well, he did say that as long as the court and the opposing attorneys got copies, I believe he said that's fine. You're hitting the deadline, but just make sure a paper copy gets here at some point. Anyhow,
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically.
I would read Judge Doolin's order to be, a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. Look, if there's a deadline set.
If that's Your Honor's interpretation, I can certainly comply with that.
Attorney Bradley and Attorney Betterow and I have it.
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that I'm not even sure that, Mr. Bradley, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk clerk's office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there, but if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
So, I don't know. I remember you mentioned the 1980s. I remember the 1980s in Boston. You had to look both ways 14 times before you set foot in a street in the financial district, because back then there were bicycle couriers. Because the attorneys are wont to wait. If you have a deadline of, say, January 1st, they generally wait until, noon on December 21st to get it done. And so they call a bicycle courier, and these guys all went around town with their pagers back in the 80s. They would stop at the law firm and they were told, go to the Suffolk Superior Court, and they'd ride their little bicycle. And I remember that building that we see in the background there, that is the John Adams Courthouse in Boston, and it does house the Suffolk County Superior Court And I remember seeing rows of bicycles just leaned against the building. Now they have bike racks. But anyhow, I digress. So the bottom line is that Norfolk County, as I know, takes electronic filings. But apparently Suffolk County, which is Boston, Revere, and some other towns, does not accept electronic filings. So that's just one more of those issues that kind of, every time we have these Turtle Boy Aidan Keaney hearings, it's kind of like remember in the Peanuts comic strip and cartoons, there's this pig pen and he's always got something swirling around.
And then what was it? Cosgrove, he acts as it sounded as if he's going to go to the court and file it. Like he's sitting somewhere with a blue background, and it sounds like he's the one that's going to have to go file the paper copy. Like I don't know. I mean, I would think he would have, some people who could file the paper copy at in a timely fashion.
Why not mail? U.S. mail, or if you're in a hurry, you wait to the last minute. We've all done it. I'm guilty of it. FedEx, UPS overnight, or so this shouldn't even be an issue, folks. I can't believe the Cosgrove brought this up. This is not an issue. This is ridiculous.
Weird. It was weird. And then you see he's a special prosecutor and he has this background, and he just looks like he's in a place like where a prosecutor, like maybe a prosecutor should be in a nice office or somewhere. But I mean, that's beside the point. I mean, he appeared and it's fine, but we're all used to Zoom hearings. But yeah, he just sounds like he's on his own. He's out there, and he did say that he only goes into the office, or what did he say at the last hearing, that he only goes into the office a couple of days a week or something?
Not even. Oh, I remember one of the hearings earlier this year. I think it was in the summer. Cosgrove had said that he hadn't even been to the district attorney's office for a couple of weeks, and he would go check. But you would think and you would hope, and I would imagine, and I'm wrong, of course, that if you get appointed special prosecutor, you would go into that office and work out of the office, and at least have a very good relationship with the people in that office, that if you needed support, they would give it to you. So anyhow, this shouldn't even be an issue in 2025. This should not even be an issue that they're talking about. Well, how are we going to file the papers? It reminds me, I'm going to date myself, but it reminds me back during the Vietnam War, they were going to have peace talks, and they spent, I forget how many weeks or months, arguing over the shape of the table. Come on, let's be professionals. All right, I digress. We closed out with Mark Betterow, again, defending Aidan Keaney, pointing out that he had just received some discovery the same day as this hearing. And this is a common thread. We kind of lurch from hearing to hearing, no discovery, no discovery. But when the hearing comes up, oh, here you go. So that's how this ends, is that the motion to remove Mr. Cosgrove is going to be heard the 23rd of January. And then the actual charges against Aidan Keaney, if they're not dismissed, and to my ear, it doesn't sound like that's going to happen, there would be a trial next November. So that's my final word on that. That's my final word on that. It just, I don't know.
It's bizarre.
It's very bizarre. It's
But
very
as a side note, I watched the Miles King hearing yesterday, and it was like, who's on first? So if you haven't watched that hearing, take a look at it, because it's bizarre.
It's and Rosemary Scapiccio is an outstanding attorney. She really is an outstanding. I'm sorry.
It was bizarre.
Okay. All right. So now there's some new filings in the Karen Reed. Is it the civil case? Her first civil case? The case against her? Right.
Yeah.
Right. So I don't want to put you on the spot, but what's this all about?
It's about the phone information from Proctor's cell phone. And she's subpoenaed. Okay, so this is a memorandum of law in support of the motion to compel Norfolk District Attorney's Office to produce data in response to subpoena. So she subpoenaed information that was on Proctor's phone. And she said she sent the subpoena to the district attorney's office, and they didn't produce anything, and so now she is filing a motion to compel them to produce it. Or
Okay.
perhaps they produced something, but it wasn't all. But we'll have to
Right.
take a look at the motion to know.
Okay, so
Or the
defendant.
memorandum. Oh, sorry.
Well, the motion is just a perfunctory. Now comes Karen Reed and moves henceforth as stated in the memorandum of law. So we're going to skip over the motion, which pretty much is repeated here in this first paragraph, where defendant Karen Reed respectfully requests that the court compel the Norfolk District Attorney's Office to produce all data in its possession extracted from cell phones owned, controlled, or used by former state police trooper Michael Proctor. Reed served a subpoena on the Norfolk District Attorney on July 24th, 2025. The DA's office produced some documents in response to the subpoena and is in the process of reviewing and producing others. However, the district attorney has refused to read the contents of Proctor's cell phone, which it possesses and has, at least in part, reviewed. Proctor's cell phone and the data and messages that are stored on it are likely to be highly relevant to Reed's defense in this case, based on limited text messages that were disclosed to Reed by a quote-unquote separate law enforcement. Who could that be? During her criminal trials, Proctor regularly sent and received text messages with fellow troopers, other police officers, friends, and family members regarding Reed, the investigation into John O'Keefe's death, and who would and who would not become a suspect. These messages bear directly on the accuracy of Reed's allegations regarding Mr. O'Keefe's death, which the plaintiffs allege was a false narrative that caused them compensable emotional distress.
Says now the district attorney has recently reviewed new data from Proctor's private cell phone that the district attorney has deemed highly sensitive and, when shared with him, caused Proctor to suddenly drop his challenge to his firing from the state police. It is very likely, based on the select messages to and from Proctor she received in the past, that this cell phone extraction relates, at least in part, to Reed. However, if it doesn't, the district attorney can make that representation in writing. Barring that, Proctor's cell phone data must be produced so that Reed can present evidence that supports the allegations plaintiffs claim are false.
So they're still fighting over what is on Mr. Proctor's cell phone. And recall the hearing by Judge Krupp in the Walsh case, but in which attorneys from, I believe, 4 other cases participated. It was said that, they had gone through Proctor's phone and the material in there could potentially affect up to 19 other cases. And then Mark Betterill corrected that and told us, well, what about the Turtle Boy cases? That makes 20. So this is a far-reaching thing. And as we're going to see in a minute, the Norfolk District Attorney is pushing back. They don't want to disclose this stuff for, their job should be, as district attorneys, their job should be to arrive at the truth. But no, they're just fighting everything. So now we get to the facts section, and I think our people know most of the facts, but let's jump to July 24th, 2025. Now we're a month past Karen Reed being acquitted. As part of her attempt to defend against plaintiffs' claims by, in part, proving that the same narrative was actually true, Reed served on the Norfolk County District Attorney's Office a subpoena, seeking various categories of documents, including all iCloud data and other data concerning or belonging to Michael Proctor received from any source, including but not limited to any federal or state agency or office, and then all communications to, from, or concerning Michael Proctor from January 28th of 2022 to the present. So that subpoena also instructs the Norfolk County District Attorney that to the extent you obtain possession, custody, or control of a document that is responsive to these inquiries or requests after you make your production in response to these requests, you must supplement that initial production with the newly acquired documents. Norfolk County District Attorney's Office has produced some documents in response to the subpoena and is in the process of completing its production.
Proctor's text messages played a prominent role at Reed's first criminal trial when Proctor was confronted with many of them in which he made derogatory, sexist, crude, and wildly inappropriate comments about Reed. In these messages, without having done almost any investigating, he assured his friends that the state police investigation would focus on Reed rather than the individuals inside the house, and that she was Reed's criminal defense only had access to these particular messages because a separate law enforcement agency conducted an inquiry into the investigation of Mr. O'Keefe's death and produced a selection of messages to both the district attorney and Reed's attorneys. But even that limited batch of text messages included many that were directly relevant to the integrity of the investigation and prosecution.
Why are we still calling it a separate law enforcement agency? I mean, we all know it was the FBI, right? It's just, that was a invention of Judge Keaney.
Super
All right.
secret.
Now let's keep it said. It's probably the worst kept secret in any law case ever. Then on October 24th, 2025, the district attorney stated in a motion for protective order in an unrelated criminal case that it had now reviewed Proctor's personal cell phone and found highly sensitive information. That was that hearing in the Walsh case in front of Judge Krupp. That information, which the district attorney disclosed to Proctor's attorneys, caused Proctor to abruptly withdraw his appeal of his termination from the, remember how fast he was right in the middle of, or another hearing was coming up in Mr. Proctor's appeal to get his job back, and the union backed away and said, no, the trustees of the union said, no, we're not going to defend you. And his attorney, Daniel Moynihan, said, this is indefensible. So from what we know about Mr. Proctor's texts, what we know already, how bad could it be? I mean, it was disclosed, and I believe it was on Mr. Kearney's channel, that there were homophobic and racist comments. And so the union said, nah, it's our obligation to defend our members, but there's some things that just are not defensible, which I would have to agree with. Why don't we jump down to the analysis?
Okay. The court should compel the district attorney to produce any cell phone data from phones used or owned by Proctor, including his personal cell phone that the office recently reviewed, because they are likely to contain highly relevant material. The relatively small number of messages Reed's criminal defense team previously received shed light on Proctor's bias, corruption, and immediate baseless disdain for Reed, among other things. There is no reason to believe that the previously identified damning messages are the only ones of their kind. In fact, it is likely that the highly sensitive information and other troubling messages that the district attorney recovered and led Proctor to suddenly withdraw his administrative appeal also relate, at least in part, the investigation into Mr. O'Keefe's death and Reed's prosecution. This data falls squarely within the scope of discovery in a civil case. And I would say that it does to a certain point. There might be some things that may not be relevant and may be more prejudicial, but the point is somebody has to make a decision on that. And in my thinking, it's usually the judge sees things in camera and makes a decision. I don't know what's going to happen here.
Well, as I've pointed out before, judges are loath to jump into these discovery disputes, but a judge is going to have to. A judge is going to have to jump into this because, believe it or not, even though we know a lot about this, as we're going to see in a minute, the Commonwealth has already filed a motion objecting to this, opposing this. Next paragraph tells us that according to the civil rules of procedure, the discovery rule, Rule 26, parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or to the claim or defense of any other party. And boy, there's a lot of parties in this lawsuit. And any information reasonably calculated to lead to the discovery of admissible evidence. I'm going to explain that because I know you know this, but a lot of people, when I'm doing discovery in my office, my clients balk and say, why do I have to give that out? That's not relevant. Well, I explained to them that A, that's not our decision to make, but B, discovery allows a much broader scope of inquiry than relevancy. We all know what relevancy is. It's something that tends to prove or disprove a fact or make it more provable or disprovable. That's irrelevancy, and that's in this box here. The discovery rules allow for penetration into anything that is reasonably calculated to lead to the discovery of admissible evidence. And that's a much broader standard, much broader to say that something is just reasonably calculated to lead to the discovery of admissible evidence. So
Yeah, so just because something is discoverable in discovery doesn't mean that it's going to come into evidence.
Absolutely. Yeah, absolutely. I explain that to my clients all the time. And I say, yeah, on a good faith basis, we have to give them this stuff. Unless it's privileged or there's some other valid objection. So plaintiffs allege that Reed is liable to them for, among other things, the emotional distress she caused them by claiming that she did not kill Mr. O'Keefe, that someone else did, and that investigation led by Proctor improperly targeted her rather than identifying the real murderer. Therefore, Reed is entitled to prove the truth of these assertions to defend against the claims.
Yeah. Reed knows from her criminal trial that Proctor sent and received many text messages that support her defense. Now, the district attorney is in possession of different cell phone data it characterizes as highly sensitive and clearly reflects poorly on Proctor. The data is likely to relate, at least in part, to the O'Keefe murder investigation and Reed's prosecution. In that manner, it is reasonably calculated to lead to the discovery of admissible evidence, and it is within the scope of Rule 26. And there's a footnote.
Should we dive into the footnote? I always tell people to, so.
I'll read it.
Okay.
Concerns about privacy and confidentiality are not a basis to withhold this data. If there are certain messages and data that is irrelevant to this case, unrelated to Reed, or privilege issues, the parties to the litigation and the district attorney can discuss and seek an appropriately limited protective order to address these topics. But the data in question is discoverable and must be produced.
And that's kind of similar to the taint team motion that was brought in the Aidan Keaney case. Remember, we were talking about that before, that they want to go through all of the material that was on Karen Reed's 2 cell phones that were seized, 2-3 years ago. But they will do Karen the favor of having a taint team, which goes through everything and determines what's private, what's tainted, what's privileged, and they'll take that out, and then the rest of it's discoverable. So it kind of almost seems like that's where this could go. Not that it would go that way, but they're kind of proposing a do-it-yourself kind of a taint team. So the conclusion, we're almost done with this document, folks. For the following reasons, Reed respectfully requests that the court allow the motion and compel the Norfolk County District Attorney's Office to produce all documents and data responsive to document requests number 4 and 11 in the subpoena, including the data extracted from Proctor's personal cell phone. Respectfully submitted, and we have all of these attorneys: Damon Seligson, Charles Waters, Aaron Rosenberg, Alan Jackson, Caleb Mason, and Elizabeth Little out in California. So they back the motion, the memorandum up with all of these documents. This is the subpoena. This is the definitions. Oh, look, Yoli, FBI. That means the Federal Bureau of Investigation. Who knew? I'm sorry.
Or the other state agency.
Yeah.
Another state agency.
Another state agency.
Or another law enforcement agency.
And believe it or not, these days you have to define what a document is. A document could include anything in the world, even electronically stored information. Yes, that's a document. It's not a paper, but under the legal definition, all that stuff in your computer is a document subject to discovery under rules 34 and 35 of the discovery rules, and 26. And so this is the subpoena. It defines everything. It's got those specific requests that we went over before, 2 and 14. It's got an affidavit of service. And so that's what the other documents are. Believe it or not, the Commonwealth actually objected. On what grounds do you say? Oh my gosh.
This is the Norfolk District Attorney's Office opposition to defendant Karen Reed's motion to compel production of data and alternatively request for stay.
The Norfolk District Attorney's Office, NDAO, is a non-party in this. That's technically true. That's technically true that in this civil action, they're a non-party, but I don't know. Am I awful to say that? It's kind of disingenuous to say that because it was their investigation that led to the whole thing.
Yeah, they're a party affiliate. Well, they're affiliated to the case. They're not parties, but it's like, somebody gets injured and they go to a hospital and then they're transferred to another hospital. Well, the hospital you can subpoena records from the hospital, even though they're not direct parties to the actual accident. So it's the same thing.
That's a good analogy. So the DA is saying, well, we're a non-party to this civil action. And so they're trying to step back in the very first sentence. They're trying to step away from it already, but then they submit this opposition to defendant Karen Reed's motion to compel Norfolk County District Attorney's Office to produce data in response to the subpoena without waiving the objections asserted in our August 1st, 2025 Rule 45 letter. That's one of the discovery rules, folks. The Norfolk County District Attorney's Office is complying with the subpoena received for specified. Well, if they're complying, why are they objecting, you may ask? Well, they are saying that they did comply with the subpoena received for specified records associated with the prosecution in the Reed case. And upon entry of a protective order, the office will produce responsive, non-privileged documents related to the resolved criminal case that are within the office's possession, custody, or control. Okay. Footnote: the district attorney's extensive record production consists of a hard drive consisting of approximately 2.5 terabytes of data. Well, hey, in the Koberger case, weren't they talking about 56 terabytes of information?
God.
So that's nothing, Mr. Morrissey. 2.5 terabytes. I have a disk. So I have one of those remote drive disks around here somewhere that holds 2.5 terabytes, and it's only like that big. But I digress. Within this data, the district attorney is producing material associated with the former trooper's work cell phone that was previously deemed discoverable in the criminal case. On November 7th of 2025, defendant Karen Reed moved to compel the district attorney to produce data associated with former Massachusetts State Trooper Michael Proctor's personal cell phone, newly acquired through judicial order in unrelated pending criminal cases. The defendant's subpoena requests all iCloud data concerning or belonging to Michael Proctor and all documents, video, or audio recordings and communications to, from, or concerning Proctor between January 28th of 2022 to the present.
That's what it requests.
Yeah. Well, January 28th would be the day that they were all imbibing in adult beverages at the Waterfall and C.F. McCarthy's. Yeah, that's the night that they all got together and met. And then the 29th is the day that John O'Keefe passed away. The defendant's motion to compel is specifically for all data in its possession extracted from cell phones owned, controlled, and or used by former Trooper Proctor. The district attorney objects as these requests are facially overbroad and unduly burdensome. And they cite the discovery rules, which we've talked about before.
So it says the defendant's far-reaching requests are not reasonably calculated to lead to relevant evidence, as the requests are not limited to defendant Karen Reed nor the investigation of Mr. John O'Keefe's death. The defendant's motion and memorandum of law seek to correlate previously disclosed and widely publicized text messages sent by the former trooper with an assumption that the acquired data contains additional communications about the defendant or the investigation into Mr. O'Keefe's death. However, the requests are not confined to communications nor communications sent by the former trooper, and the defendant has information readily available about the former trooper's unprofessional and biased conduct and has directly sought access to this data through a subpoena issued to Michael Proctor, who, as the record holder, can directly address issues of privilege. So they're saying that the subpoena to Michael Proctor, that he can address it.
So as though we would trust the dishonorably discharged Trooper Proctor based on everything that we know about him. I mean, again, they're backing away and saying, what, me worry? No, we want as little to do with this as possible. And they're avoiding the fact that what was available during the criminal trials, plural, of Karen Reed were then expanded upon later on when it was found that not only did Michael Proctor tell him his truth when he said that, oh, well, he got a new cell phone the previous year and he deleted everything every 30 days. So you're not going to get anything. But really, they were able to get things going all the way back to 2013, 12 years of information. So it's a new ball game as far as I see it. I don't know.
Right. Right. And what they're saying is for good cause, that they can get, if someone can get, if you pull up the document a little bit so I can see. It says, yeah, for good cause shown, the court should protect record holders from undue burden or expense, particularly when the material is available from some other source, duplicative, unduly cumulative, and in considering the importance of the requested material and resolving the issues. Well, the record holder has already said he's deleted things and they were able to recover things. So how reliable is the record holder, Proctor? He's not, like you just said.
This is the kind of BS that I deal with in my civil cases when, we're dealing with a huge corporation that has offices there in California and New York and Georgia and all over the place. And they just point the finger around and they say, well, this other corporation that's involved in the litigation, they have it, but they've already said, no, they have it. So you got people pointing the finger all the way around in a circle. No. If you have this data that somebody else has it, that's no excuse, Norfolk County District Attorney, the way I see it. I mean, they should just say, here it is. Why are they fighting so hard? They fought so hard in the Reed case to keep it out. They fought so hard initially in the Walsh case to keep it out. Why are they fighting so hard? What do they have to hide? Why are they still playing this shell game? Nope. See no evil, hear no evil, speak no evil. We're not going to, Why are they still playing this game? I mean, the cat's out of the bag. We know that Proctor is dirty. We know he said a lot of stuff, and there's all this new material that's out there. Why not just turn it over, guys?
Yeah, and just because it's discoverable doesn't mean that it's going to be used in a trial. So whatever is not relevant can just be, they can file a motion in limine to exclude it. But I think the issue is this is such a highly publicized case that they're afraid that even if they do turn it over, it's going to get all over social media, or the media is going to be talking about it. And then, it's just going to make him look even worse. But I mean, at this point, I don't know. It seems.
How can he look even worse? I shouldn't even ask. How could he look even worse? I don't even want to know. Anyhow, this is an interesting paragraph. The data from the former trooper's work cell phone and personal cell phone include text chats, audio files, pictures, and videos that span many, well, all of us have all that stuff. It spans many years, and in some instances, predate the former trooper's employment as a law enforcement officer. The data includes an abundance of privileged information between spouses and attorneys. Okay, cut that out. Not a problem. And attorneys, as well as highly sensitive and personal information unrelated to any criminal or civil matters. That's fine. Cut that stuff out. We really, I don't care if his wife called his cousin and said, you want to go to the Star Market tonight and pick up a roast beef? I mean, I don't care about that. All right. That, and you know what I care about.
In California, we do a privilege log. So we
do too. Yes.
Yeah.
Yes.
So there's no reason why that can't happen here.
Exactly. The defendant's request for unfettered access to the entirety of this data would result in the production of privileged and non-relevant information for far exceeding the bounds of relevance surrounding the liability. They're just coming up with excuse after excuse after excuse to not come up with the goods.
Further, the Commonwealth objects as the defendant's requests are unduly burdensome to the district attorney and its limited resources. The district attorney's possession of certain data extracted from former trooper Michael Proctor's personal cell phone is pursuant to and restricted by a Norfolk Superior Court order. On June 17, 2025, the Norfolk Superior Court, Michael Doolin, allowed in specified cases, and the cases are listed below, which are like
Right.
Miles King, Sean Johnson, and others, defense motions for discovery of former Massachusetts State Police Trooper Michael Proctor's personal cell phone. The order included that the Commonwealth produce communications from the dates of the charged offenses to the dates that indictments issued in those cases and produce any other data from Proctor's personal cell phone that constitutes investigative materials or is favorable to the defense. On August 13th, 2025, the Norfolk Superior Court Peter Krupp modified the order, clarifying the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range, and that the former trooper had a legitimate interest in protecting attorney-client or spousal communications. The Norfolk Superior Court issued further orders about delivery and extraction of the phone, the opportunity for the former trooper's counsel to submit a privilege log, a timeline for the Commonwealth to produce discoverable materials, and notably restricted the possession of any responsive material. And there's a footnote, but let me just read the last sentence.
Okay.
The defendant's overbroad requests contravened court orders as to the permitted scope of reviewing in pending criminal cases and contravenes orders on privileged information.
That is a conclusion that's unsupported by the facts. I mean, just to say that it's overbroad, I often find that defendants who just don't want to give you stuff, that's unduly burdensome and overbroad. That's like boilerplate that's in the rule. And I find that people just boilerplate throw that language out there because they don't want to do it. They have something to hide. That's all it is. So now you want to read footnote 3. Oh, that's just the cases.
Footnote 4 says relevant data extracted from former trooper's work cell phone is also being produced to criminal defendants subject to stringent protective orders. Okay.
Yeah, but that was in the Walsh case, and the attorneys that came in, for example, in the Commonwealth versus King case, that was Rosemary Scapiccio's case, and the other attorneys also participated in that hearing. So I think this is a lot of the same, don't you?
Yeah, they're talking about non-party record holder, the burden and cost to review personal cell phone data of a non-party for a variety of unknown and evolving theories of liability is unduly burdensome to the district attorney.
Now, this is a Commonwealth that spends millions and millions and millions and millions of dollars every year on God knows what. They have a huge, state police bureaucracy, and they say, we don't have time to do it. Is that a reason not to produce significant, relevant material that has proven to be extremely probative in the previous Karen Reed case? Is that a reason? Oh, it's too much work. I'm sorry. It sounds like a kid that doesn't want to do their homework. They just, it's just, no, we don't want to do it. That's how I read that final paragraph.
It's just common language that is used when you're fighting discovery, and it doesn't really mean anything in most cases. It just means we're just opposing it.
Yeah, the burden and cost to review the personal cell phone data. Yeah, that bad excuse. That's like the dog ate my homework. Okay, conclusion. For the reasons stated above, the district attorney's office respectfully requests that this honorable court deny the defendant's motion to compel, as the request is overbroad, unduly burdensome, and harassing to the district attorneys as a non-party record holder. So they mentioned that they're a non-party about 5 times. Alternatively, the district attorney requests that this honorable court stay the defendant's motion to compel until the district attorney has completed its review for discoverable material in pending criminal prosecutions, and in consideration of the defendant submitting a narrowly tailored, date-restricted request for a specific category of data. Well, how do you know what the categories are unless you take a look at it?
Yeah, this is what would be subject to a meet and confer. Where you meet and confer with a non-party who has records and you try to narrowly tailor it to what you want. But you got to see first what you have, and then you can but it involves trust. It involves some level of communication that, okay, these are not obviously not relevant. So, that's what we do in California, but here it just seems, I don't know what's going to happen. I don't know.
There's something really rotten in this case. And yes, people are going to say, "Oh, Attorney Myers, you're just realizing that now." No, I've realized it for a long time. But the fact that it just continues and continues and continues, just there's something really rotten in this case where, I mean, they're
And
fighting so hard. How is it any skin off of their nose unless it's so bad that it just implicates everybody in the DA's office, that they've been stonewalling us all along on a lot of different issues? I mean, why are they fighting so hard? Why don't they just give it over and say, okay, there you go, guys. That's the alternative that would make sense to me.
and it could be subject to a protective order where you're not going to disclose it to anybody unless it's a party to the litigation. And you keep it under wraps so that if any social media or whatever starts sharing this information, they get in trouble because they're violating this protective order. And then they can do a motion in limine to exclude whatever the plaintiffs or the district attorney can basically say what we've agreed to, the texts and whatever messages we've agreed to, and these other ones don't come in. But it takes civility, it takes communication. And it's so broken down there. I don't know, because this is the O'Keefe's lawsuit against Karen Reed, and she has a right to present a defense. And one of her defenses is that Proctor was biased, the investigation was biased, that she was essentially not liable for, or not criminally liable for, the death of Mr. O'Keefe. So these are all, if people could just think logically and just try to work it out so that the case can get moving. But no, it's all request a stay until we can look at this.
You know what I'm thinking? You know how horrible those Michael Proctor texts were? That was so horrible. He didn't want to read them himself, and Judge Keaney made him read the C word, and it just was just the most disgusting stuff ever. My thought is that they are fighting so hard to release all of this stuff that it's even worse than that. So I don't know.
Yeah, I mean, I would imagine that any bias, I mean, not any bias, but bias against women would likely come in.
Well, yeah, they said that the material that we haven't seen yet contained references that were racist and homophobic. Well, what else is in there? What else is in there? He just, for whatever reason, he didn't like Karen Reed. She has a weird Fall River accent. Well, so what? And all the other things that he said about her. So I don't know. This is these cases are going to go on forever, and there might still be another case. That the case we're talking about here, correct me if I'm wrong, is pending in Plymouth County, Massachusetts. The case that was brought by Karen Reed was brought in Bristol County, and then that was removed to the federal court. We don't know whether there will be a motion to remand yet or not. Yeah. We don't know that. But now the House defendants, I guess we'll call them, are threatening yet another lawsuit. So
yeah, so I like all this procedural stuff. I like talking about it, but in reality, like, it just needs to be made a little more simpler, and people need to, the public, like the press, needs to be able to follow the case in a logical fashion. Like, if it says that this is going to be a hearing for such and such on this motion, then it's a hearing on such and such on this motion. I mean, the information that's given to the public has to be accurate, at least as much as possible. You can't have these floundering hearings where everything is talked about and nobody knows what's talked about unless you're on Zoom. And it's just,
I wonder how long these cases will take. They've already talked about 2027. So I just wanted, the federal court does tend to adhere to stricter time lines. They give you an idea. Here's how it's going to go. And, come hell or high water, you've got to meet those dates. If you don't, you're in big trouble. Yeah. So No comments this week. And before we get to our closing thoughts, we don't have comments, but I'm very proud to announce that my dog, Lily, turns 15 on the day that we are dropping this episode. And so I want to share with you a little bit about Lily on her 15th birthday. Lily the Legal Beagle. As we drop this, she is now 15, her 15th birthday. We call her the Legal Beagle because she likes to go into the office and act like the door greeter. In fact, if she's not there, people say, "Hey, where's Lily?" Lily likes to hike. She likes to just sit by the water. She actually is the only dog I've ever had that likes to watch TV, and she watches it intently. So a lot of people want to wish Lily a happy 15th birthday.
Happy birthday, Lily.
Happy 15th birthday, Lily. We love you.
Happy birthday from your vet, Lily. Happy 15th.
Lily! Lily! Happy 15th birthday! Happy 15th birthday, Lily! Good girl.
Happy 15th birthday, Lily. Roll over.
Happy birthday, Lily.
Happy birthday, Lily.
Happy 15th birthday, Lily.
Happy birthday, Lily. Many, many more.
Happy birthday, Lily. And then it was so nice. You never scared me, and I'm afraid of dogs, but you never scared me at all.
There you go. Happy birthday to the killer dog of the neighborhood, Lily, 15 years old.
Happy birthday, Lily.
I'm Lily's neighbor. Happy birthday.
Happy birthday, sweet Lily. We all love you.
Happy 15th birthday, Lily.
Hey, Lily, it's your favorite mailman, Bob. Happy 15th birthday. Enjoy your day. Eat lots of treats.
Happy birthday, Lily. You're 15 years old now. Behave.
Okay, so with all of that aside, I just hope that everybody that has a dog that's as long lived as Lily. I know that they can live a lot longer, and I hope that she does. And I'm thrilled that she's been around this long. She's been in pretty good health. She has pretty bad arthritis, so we don't go for quite as long hikes as we used to. But she still does like to go out. She likes to hike. She likes to play, and she gets a shot for her arthritis once a month. So, anywho, do we have any closing thoughts? My only closing thought is, why are they fighting this so hard? Why is the district attorney's office, which, as they themselves pointed out, we're a non-party. So if you're non-party and you have no skin in the game, disclose it. What's the problem? I know what the problem is. It's that Proctor probably was even worse than we know about. We know about some of the bias that he had as expressed through his communications. My thought is it's probably much worse than that. What's your closing thought?
At this point, my closing thought is just that, this is going to go on for a while with these discovery fights. And it's going to be interesting, I think, because, the procedural issues involved and everything. But those are my closing thoughts. I'm just looking forward to see how it proceeds in the courts and all these separate cases in different forums. It's interesting, but
it is interesting. So we don't sell merch. We don't ask you for money. We can buy equipment if we need it. And we don't run ads, even though we've had some proposals to run ads. So it is free to subscribe. And we're asking you right now to go down below, click subscribe. And as a few characters from the Karen Reed case are going to tell you right now, remember, it's free.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
All right, so let's see. At the end of every episode, we ask people who have been with us, and this is longer than what our usual episodes. We ask people to drop us an emoji to let us know that you watched the whole way through. What's your idea for an emoji this week?
I don't know.
How about a dog?
Or dog? Yeah, a dog.
How about a dog? Let's celebrate Lily's 15th
Yeah, there you go.
birthday and give her a dog
Yeah.
emoji.
A dog and a happy birthday.
There we go. There we go. That's a good one. Thank you. Thank you. Okay. So be nice, be kind in our comment section. If you don't like something that someone else has said, I would prefer that instead of calling them a name, tell us why you think the way you do. If you know of a legal case, or you know of some precedent, or you know of some facts, or you've read something that is going to enlighten us, that would be great. And that brings us all up. So thanks for watching. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.